Lou and I are here, raring to go this morning with a delightful update in relation to COVID. So it's been a couple of months since we've done a COVID update, and a lot has happened since then. So we thought it would be quite good to regroup and see where we are, and also have a little glimpse at the future and what's coming up. So as always, the webinar is live, so please do feel free to ask questions throughout the webinar, and we will set aside some time to answer these. So this morning, what are we going to look at? We're going to have a health and safety update by Louise. So she will talk about the updated guidance, a discussion on flexible working, and both of us indeed are actually going to talk about vaccinations from a health and safety perspective and an employment perspective. We have previously done a webinar on purely devoted to vaccinations, and that will still be available. The recording is available, so do email us if you have particular interest in that area. I'm also going to talk about employees returning to the workplace, because I think, as Lou will kindly tell us, the rules are changing, and so it is anticipated that more and more employees will be coming back to the workplace if they've been working from home up until now. And of course, we will talk about the reluctant employees. I also am going to spend some time this morning talking about hybrid working, which is a new topic for a webinar. We haven't talked about hybrid working yet. And what I would be really grateful if you could do is that Amy, who's working in the background and helps makes all the magic of the webinars happen, is going to put up on your screen any second a poll, a little survey which we would like you to respond to, and it's just essentially asking whether you're planning on implementing a hybrid working model in the workplace, and I can see many of you are answering already, so thank you for that. Amy, are you able to? No, it's all right. I've worked out how to get back to the slides. That's fine. And then I'm just going to do a little bit of a general roundup, just a few points, just in terms of what is up and coming and trends and issues that we're noticing at the moment. So I'm going to immediately pass over to Lou, who's going to give us the health and safety update. Thank you.
Thanks, Vanessa. So I'm going to start off with regards to the updated guidance. As I'm sure most of you know, on Monday, Boris announced the next step with regards to stage 4 of the roadmap out of restrictions. He said that confirmation that the next steps are going to be taken will take place on Monday. So it'll give businesses and people a week or so to know what's coming on the 19th of July. The suggestions at the moment are good in that we are now moving to stage 4 of the roadmap. So I thought I'd just do, first of all, a general update, and then what's more important from an employer and workplace perspective with regards to the guidance and how things are changing and what's coming up, hopefully on the 19th of July. So the plan across the board is to move towards enabling the public to make more informed decisions themselves. We've had a lot of restrictions, and those restrictions have been placed into legislation over the last 16 months or so. The idea is that we'll move away from that legislation. Mostly, there are some parts of legislation that will still remain, but the idea is that people make more informed decisions themselves. There will still be guidance, but it is guidance as opposed to law. So the main thing, social distancing and face masks will no longer be mandatory. With regards to social distancing, there are still some parts of society that will still be subject to that, border control, and where there's ports of entry, the suggestion is that that will still remain there. And with regards to face masks, they will no longer be mandatory, but as I'm sure you're probably aware, I know that some businesses such as airlines are still going to be requiring it on their flights. But across the board, generally, they will no longer be mandated by the government, which is a big change for us. In certain areas, certainly, as you'll know, you could be fined if you weren't wearing one, unless, of course, you're exempt. All remaining limits on social contact will be removed. Whether you're indoors or outdoors, you will be allowed to socialise with whatever number of people you want, basically. And all settings will be open, and all restrictions on events will be removed. And that is the plan for stage 4 of the roadmap. Some of you may also know that at one point there was suggestion that in particular attending domestic premises, COVID status certification was being mooted. Now, this would have meant that you would either have to prove your vaccination status or prove that you've got a negative test to enter into pubs or certain events. At the moment, that's been put on hold. The suggestion is that won't take place. My understanding is that the concern was that the impact on businesses trying to implement that would be such that it just wasn't a cost-effective method. So at the moment, that has been parked. However, I think the guidance will be that it will still be up to certain organisations if they wish to require that. Again, it won't be mandatory. And there could obviously be certain equality issues if, for example, you have someone who's exempt and where we have the vaccination program ongoing, where certain younger people still haven't had double jabs. There's particular age discrimination issues that may arise. As I said, at the moment, it won't be mandatory, and that is not the plan. The main part of the legislation, however, and the main COVID regulations that were put in force that are still to be retained are the test, trace and isolate plans. Now, therefore, if you are required to self-isolate and you don't, you could still be fined. At the moment, as I said, whereas we had a whole raft of legislation with regards to social distancing, with regards to face coverings, that legislation will go, save for this piece of legislation in respect of the requirement to self-isolate. And again, if you breach that requirement, you can be fined. You'll also know from, I think it was Tuesday, where the suggestion is now that if you are doubly vaccinated, if you are contacted through the test and trace app, you will no longer be required to self-isolate. It's important to note that's different if you test positive. You will still have to self-isolate even if you've been doubly vaccinated. So that's the update with regards to the guidance, or the main highlights in terms of the guidance in general that applies to us from a personal and from a workplace perspective. What do we need to think about in particular in terms of the workplace? Well, as I'm sure you'll know, up until now, the guidance has been mixed with regards to where we should be working. Over the last 16 months, we've had you must work from home, then you can if it's reasonably practical, then you can only go into the workplace if it's impossible to do your job from home. That instruction to work from home will be dropped as of the 19th of July, again, provided that it's all authorised to proceed next Monday. So the working from home instruction is dropped, and the idea is to encourage people to come back into the workplace to assist with the economy's recovery. So what does that mean? What's going to happen next? Because we aren't out of the pandemic yet. There's still issues in the background. We don't know what's going to happen over the next few months. Now, as I've just highlighted, the legislation with regards to working from home, and that will be dropped. But what the government are going to do, and I anticipate that this guidance will perhaps come out next week after the formal announcement on Monday, they'll update the working safely guidance. Now, as most of you are probably aware, the government have produced over the last 16 months a raft of guidance and information with regards to how you can work safely during the pandemic and what employers should consider. There have been requirements to undertake a specific COVID-19 risk assessment and to put in place COVID secure practices and policies in your workplace to ensure that people that are attending the workplace are safe. That guidance is going to be updated, and we anticipate that what that guidance will focus on is more about encouraging safe hygiene practices, thinking about ventilation in the office, thinking about the layout still in terms of perhaps not placing people so closely together and trying to reduce the amount of contact still whilst we're still in these stages and whilst we're sort of seeing what happens over the upcoming months. It will be guidance, it won't be law, and that's the difference to some extent. I would, I'll do an update next week when that guidance, or as soon as that guidance is released, with regards to what the main points are and what employers are to consider, and that I'll circulate that article as soon as I know what that guidance is and what it means for employers. With regards to self-isolation from an employer's consideration, however, you still need to ensure that if you have staff members that do need to self-isolate, that they should do so. They should not be required to come into work. As I highlighted before, that legislation in respect of self-isolation will remain. And if you breach those, if you breach that legislation, you could be subject to a fine. Not only the employee can be subject to a fine, but as an employer, if you require someone to come into the workplace who should be self-isolating, then you can be fined as well in line with that legislation. The other points that I think will remain and that we anticipate will be covered off in the guidance when it comes out is that you should continue to ensure that those who are unwell should stay at home. And the other point that should be noted with regards to employers and businesses is the QR codes for the NHS test and trace will, again, it will no longer be a legal requirement. But again, I anticipate that the guidance next week or whenever it comes out will encourage businesses to still use that. So they're the main changes with regards to what's happening and what employers need to be aware of. As I said, let's wait for the guidance to come out next week and we'll do an update with regards to what employers should still be thinking about. Practical next steps then from the employer's perspective. Let's wait for the guidance and see what it says. And then I'd be suggesting that you look at your practices and procedures. Whereas most restrictions are being dropped, hopefully, on the 19th, we've got to also bear in mind that over the last 16 months, whilst people are coming back to the workplace, whilst you're encouraging more people to perhaps be back in the workplace, there is still a high level of anxiety across the board with regards to what's going to happen in the coming months. So I don't think I'd be advising from an employer's perspective that you just throw everything out of the window as of next Monday if we do proceed. Sorry, as of the 19th, if we do proceed. I think you need to be mindful that there are still a number of vulnerable people and vulnerable employees out there, and you need to be having a think about what your practice and procedures are. Have a look at them. Look at the ones that you want to perhaps keep in place for the time being. Look at what's going on, and key is always liaise with your staff and decide what works the best for your business and individuals. Businesses have been hampered by having people working from home and the way that we've been working over the last 16 months. And I appreciate that we're keen to get people back into the workplace. I'm also aware that businesses have spent a huge amount of money and resource and time putting in place their COVID secure guidance. I think while we're still in the unsettled times at the moment over the coming months, that to therefore then just get rid of all those guide practices and procedures that have enabled your workers who have come back to the workers to feel safe and to get on with their job, to just throw them away. I probably wouldn't advise going down that route at the moment, but just have a look, see what's going to happen, see what people are comfortable with, take into account your staff's concerns and liaise with them. Make sure that you've taken into account individuals' needs as well as what the needs of the business, so that as restrictions are hopefully eased, those people that are coming back into the office and perhaps working in closer contact with their fellow colleagues than they previously were, make sure that they're happy and see what can be done to ensure that people are happy in the workplace to enable them to get on with their job. So I think that's the practical steps at the moment. Let's see what the guidance says. It is guidance, it's not mandatory, but I think you should heed those practices and procedures for the time being, certainly over the coming months, whilst we're hopefully coming out of this situation that we've been in for some time now. With regards to flexible working, our working practices have changed substantially over the last 16 months, and I know that a lot of employers are probably going to be taking those new working practices forwards in the future. So it's just a reminder with regards to your health and safety duties if you're now looking at more flexible working. So you have employees who are either permanently working from home or those that are coming back to the workplace. If you've got a mix of that, what should you be thinking about? Well, the upshot in a nutshell is that your health and safety duties to those employees, either working in the workplace or at home, are exactly the same. If they're in the workplace, again, as I previously said, consider the updated guidance when it comes out, and consider your working practices, consider what you can do, and liaise with your employees to make sure that everyone's happy, or as best you can, really make sure that everyone's happy with regards to returning to the workplace. If you've got workers now more permanently at home, whether that's on a full-time or part-time basis, again, your duties are to provide reasonable and sufficient equipment for them to do their job, monitor their well-being, and make sure that you keep in contact with them. Whether you have employees in the workplace or at home, you will need to ensure that you've undertaken sufficient risk assessments for both situations. If you've got employees working from home, they still need to do a risk assessment, whereas previously the health and safety executive and their bodies required you to perhaps even go into their home to do a risk assessment. That isn't the case anymore. If you can give your employee the tool to undertake the risk assessment themselves of their workstation to ensure that there are no physical or psychological issues to them getting on with their job at home. So the idea is, whether you're in the workplace or whether you're at home, you need to be undertaking risk assessments with regards to the return to the workplace and with regards to your employees' workstations, bearing in mind the pandemic that's still rumbling on in the background. Again, the key point, whether or not you have employees working from home or in the office, is communication with your staff and a balance between the needs of the business and those individuals. So the thorny topic of COVID vaccinations. I just thought I'd just give a brief update with regards to where we are. Hopefully by the end of the summer, most adults will have had access to both jabs. There is a plan now to do a booster vaccination program to run from September 2021, and that's going to be rolled out in 2 stages. The first stage is over 16s who are immunosuppressed, older care home residents, over 70s, and frontline healthcare and social care workers. And then the next stage will be all adults who are over 50 and 16 to 49-year-olds who are at risk. And you may recall there were 2 categories of risk. You had those that were clinically extremely vulnerable or clinically vulnerable. So that's the plan from September, is to run that booster program, and that will be rolled out later this year. So what's happened in terms of vaccination since we last did our vaccination webinar? Well, the care home industry have confirmed that, or the government have confirmed that it will be a condition of employment in care homes, and that should be coming into force as of October. My understanding is that there will be a 16-week lead-in, so those employees who are working in care homes have got time to get both vaccinations and perhaps even their boosters if applicable, so that they can carry on with their work. Off the back of that, there's a consultation that will be taking place later this year with regards to whether or not they're going to extend that mandatory vaccination to further social care settings and healthcare workers. It's a thorny issue at the moment. There's arguments on both sides where you have employers or businesses that have either clients or employees that are working at a higher risk of either contracting COVID or from passing it on to those that are more vulnerable. Then this issue is obviously more important than other people who aren't working in those higher risk businesses or industries. The other issue that a number of employers have got to face is that the concern is that by making it mandatory, they may well lose a section of their workforce, and in particular the care industry. I know that there's concerns that they will struggle to recruit off the back of this guidance, or this legislation that will be coming into force later this year. It's a fine line, it's a difficult balance, and there's lots of arguments for and against. With regards to the law as it stands, you cannot legally force someone to have the vaccination. Whether or not you want to consider your own vaccine policy, again, will depend on the level of risk to your industry and how therefore important it is on your agenda. My advice at the moment would be, unless of course you're in the care industry where it is coming into force, that you perhaps don't go down the route of making it mandatory for your employees at the moment, where we are still in the early stages of the vaccine program. We still don't know, although the signs are good, of its efficacy. And also, if you're subject to boosters, you have potential issues with regards to everyone getting that, how that's going to be practically administered within the workforce. And you've also got the situation that you need to balance what is a reasonable instruction from a health and safety perspective, and whether or not requiring someone to be vaccinated as part of your employment contract, whether or not that's reasonable. I think I've touched on before, I work from home a huge amount of the time. I think it probably found to be unreasonable for pretties to request that I be vaccinated, but I'm in a different situation as opposed to someone who's working in a care home or who is on the front line, who is more likely to pick up perhaps COVID or to pass it on. It's very, very difficult. It's a hard balance to strike. We're still in the early stages, and we still don't know what's going to happen over the next few months. I think the best thing that you can do, in particular where you have concerns, is to encourage employees to have the vaccination in line with the government guidance and inform them of the benefits if you think that's appropriate. Again, it will be very much dependent upon your industry, your employees. If you have a high level of vulnerable employees, then it's again something that you want to take more seriously or have more thought to at this particular moment in time. It may well be that going down the line, you want to have a vaccine policy in place. Again, you're going to have to assess that. But I think at this moment in time, unless you are in a specific industry, you hold off on doing that. The key is always liaising with your staff. However, have sensitive dialogues, take into account the fact that different people have different opinions on it and they're coming at it from different viewpoints, and just try, and if you can, encourage people to get vaccinated, but take on board their concerns or their queries and think of other ways around it, rather than going down the mandatory route at this stage. Again, keep up to date with the guidance and what's going on, so that you can, if you do need to make changes to your policy, then you're aware. And if it is something that you want to consider for your business, I would certainly encourage you to get legal advice at this stage. So that's all I've got to say at the moment in terms of health and safety update. I can see, Vanessa, I think if it's all right, I'll deal with these inquiries on a health and safety perspective now. Is that all right? Shall I cover those?
Yeah,
off?
I was going to suggest
Yeah.
that. Great, thank you.
So the first question, does this mean employees now need a designated home working area and desk, not working off kitchen table? If moved to permanent home working, otherwise cannot agree. Does this mean employees now need a designated home working area? No, not. I think provided that they can work safely in their home and they've undertaken that risk assessment to say that they can work safely, I don't think you have to have a designated area as such. Certainly I move around in the house depending upon whether or not my husband's doing a call or what's going on, and so I don't have a designated area, but I have undertaken a risk assessment to ensure that where I am working is safe. And I think a lot of us do that in any event, wherever we're working, to make sure there's no leads about and all the rest of it, that it's a safe environment, that you're comfortable where you're sitting, you've not got glare, all those kind of issues. But I don't think you need a designated area. If, however, you have permanent workers who are working from home and perhaps they're saying that they have physical problems with their workstation set up at home, and there's something you can do to assist that, whether it's an ergonomic chair or a desk or something that you can do, and it's within your means to do, that's an issue as well for many employers, then I think you should be looking to do all that you can to assist. We're checking that covers off if moved to permanent, otherwise cannot agree to home working. I think that covers off that question, but please let me know if it doesn't, or if I've got that wrong. Is there any new guidance about employees wearing masks, gloves, etc. in the hospitality sector? I will find out. I suspect there'll be guidance, but again, it won't be mandated in law. No, as I said, normally they update it. I understand that they're going to be recommending that where in particular coming into contact with strangers or crowds, that you may want to wear them, but it's not going to be mandatory as far as I understand. The hospitality sector will have a specific set of guidance that will come out off the back of the restrictions being lifted. And I'm hoping that that guidance comes out next week ahead of the 19th of July. So employers and businesses know what they're going to be looking to implement. It may even be, if it comes out later this week, then even better. And I'm keeping an eye on that at the moment, because as soon as that comes out, but there will be a specific sector guidance coming out that will cover, or it should, I anticipate it will cover face coverings in particular. So yes is the answer. I don't know what that will say. My guess is that it will be, if you're in crowds, then you can you'd encourage your employees to wear them, but it won't be mandatory. The next question, we work with vulnerable adults. We have a few staff who are refusing to be vaccinated, therefore asking them to continue using masks and keeping a distance. In this group includes those from the Black community. Obviously, we understand the concern, but are we okay to carry on with this guidance? Yes, at the moment, unless you're in a care home setting where that will change and you'll have other considerations. It's not mandatory. You need to think about your vaccination policy, and I think you need to have in place if you're working in an area where you have heightened risk, then I think you do need to be thinking about your vaccination policy a little bit more and thinking about what you are going to be telling your employees and what you are going to be considering. If you've got staff who are refusing to have the vaccination, it's not mandatory for them at the moment. It sounds like you are therefore asking them to use masks and keep a distance, which is a reasonable and proportionate response. So it sounds at the moment like you're doing all that you can to make sure that you're taking the steps to protect your employees and those that they're working with. So yes, it's okay to carry on with this guidance. I think that's appropriate in the current time. Thanks for you clarifying regarding not needing a specific designated work area. What about if employee only has a temporary table to work for? So in family area with no confidentiality. I think if you have concerns about their working from home in those conditions is having an impact upon their job, or it raises concerns in particular from a confidentiality point, then I think you need to have a conversation with them about whether or not they can effectively and reasonably do their job from home in that situation. And I suspect that should, well, I think that should be the first step, and speak to them about their concerns, whether there's any alternatives. It may well be that if your concerns in particular, because of the nature of the work, means that there will be a breach in confidentiality, then I think it would be reasonable to ask them, if you can, to come back into the workplace. But you need to have those conversations, and you need to have those open and frank and sensitive conversations with those employees to see if there's a better option, bearing in mind your concerns and theirs. But please do message me if you've got any further thoughts or any queries on that. And then, if we instruct employees to return to the office to keep third-party data secure, does the employee have a defence to decline our instructions because the employee has worked successfully, securely for the last 18 months? Vanessa, is that more your...
Well, yeah, but what I was going to say is that your answer to the previous question is just as applicable to that question. Because if you as an employer have concerns about employees working from home in relation to the business needs, in relation to whether they can properly perform their job at home, in relation to any other issues such as third-party data security, then it's reasonable for you to instruct your employees to return to the workplace. And indeed, I'm not sure what your kind of agreements were at the time in relation to employees working from home. And certainly if you made it clear if you made, sorry, I had an incoming call. If you make it clear, if you made it clear that this was a temporary arrangement, then that obviously puts you in a much stronger footing in terms of getting them back to the workforce, and that temporary arrangement has ended. We now need people working back from the office. And
I think if that's a policy you're going to have across the board, then I can see that they've got a defence to some extent to say, well, I've worked successfully at home, but there's been no issues. And if they're going to make certainly a request for flexible working, I can see that could support that. But again, I think you need to look at your practices and policies across the board. And if you feel that there are concerns about data protection and confidentiality, and for those reasons, and they're reasonable reasons, you want everyone back in the workplace, and I think at this stage, if we are dropping the work from home policy, then I think that's reasonable. But again, where we're still coming out of this, there's a lot of anxiety for a lot of people, in particular those that are vulnerable. It's all about having those conversations and all about airing those concerns and trying to come to some kind of agreement that works best for both employees and the business. Thank you. So if the employee refuses to return to the office and we cannot accommodate working from home, are they in a position that they should resign? I think that, sorry, Vanessa, I think that might be one for you again.
Yeah, no, well, it is, isn't it? I mean, it's either they resign or you're going to have to kind of start a process to potentially terminate their employment.
Yeah.
And I suppose conduct would be one of them, breaching their contract, which is, presumably to fulfill their duties and to work where the contract says to work, which presumably will still be in the office. Or the potentially for another fair reason could be some other substantial reason, or indeed, it would be disciplinary and failure to follow reasonable management instruction while you get back to the office. So yes, if you get to a stalemate, then certainly you're in a strong position. But of course, what you will need to do is listen to the reason as to why they're refusing to return and what their concerns are. If it's just because they find working from home more convenient, then you're in a much stronger position, as opposed to if they, need to work from home because of an adjustment due to a disability, for example, or if they've still got concerns And I'll come on to, in a moment, reluctant employees and the Section 100 and Section 44 of the Employment Rights Act, where employees are refusing because they still consider there to be an imminent danger to themselves or others if they return. So I think we will probably move on to my section, actually, because I think some of the questions coming through are kind of linking on to employment, aren't they? And hopefully what I'm going to cover in a second will help answer those questions. So just continuing on the theme of vaccinations, I'm not going to talk too much about it because Louise already kindly covered it, but a quick note to look at the ACAS guidance on this, because it has been regularly updated throughout the pandemic, and is also always a useful source. But at the moment, its position remains the same in that it simply advises employers to encourage and support their staff to take up the vaccine without making the vaccination a requirement. With relation to mandatory vaccines, obviously, as we said, mandatory in adult social care settings from October, but of course there's a specific set of circumstances and rationale for that. So therefore, for other businesses that don't fall within that category, requiring an employee to be vaccinated, forcing it on employees as a condition of them receiving work could potentially amount to a repudiatory breach of contract, entitling the employee to resign and claim constructive unfair dismissal. The other potential risks you need to consider are obviously potential discrimination risks. We've got disability discrimination, because of course we know that vaccines are not suitable for certain individuals, such as those with suppressed immune systems or those with certain allergies, by way of example. So some employees are being advised not to have the vaccine. You've also got to consider your pregnant employees or those that are on maternity leave. The current government guidance is that pregnant women should be vaccinated, but of course the previous advice was that they shouldn't be vaccinated. So understandably, this change in advice may well lead to some pregnant employees being concerned about having the vaccine and being cautious. I think race has already been mentioned in one of the questions, actually, but of course there's differences between the different ethnic groups as to willingness to receive the vaccine. And it is also possible, although there hasn't been any cases on this, that the protected characteristic of religion or belief could protect certain religious or moral objections to the vaccine. We also know that the rollout prioritised older employees, and so only allowing vaccinated employees to return to the workforce, say from the 19th of July, may lead to direct or more likely indirect age discrimination claims by younger employees because they haven't had the chance to be fully vaccinated. Most likely kind of claims would be indirect discrimination as opposed to direct discrimination. And of course, a defence to indirect discrimination is where an employer can justify the requirement, but you need to justify it as being a proportionate means of achieving a legitimate aim. And the burden would be on you, the employer, to show that justification. Establishing a legitimate aim is potentially the easiest part of the test, because of course you'd be talking about protecting the health and safety of staff, of service users, of any third parties. And it's unlikely to be an uncontroversial legitimate aim for an employer. But of course, the proportionate means is where employers are likely to become more unstuck, because you've got to show that your actions actually contribute to pursuing that legitimate aim. And as we know, when looking at the health and safety grounds, whilst vaccination does reduce the chance of a vaccinated individual contracting COVID-19, we now know that that risk is not eliminated. And actually compliance with the most recent up-to-date government guidelines, introducing regular testing, still having some home working to keep space in the working environment, they are all examples of less discriminatory means of achieving that health and safety legitimate aim. So I think with mandatory vaccines, I'll echo Lou in saying that, you know, there are risks if you a real risk if you go down that route. I just wanted to quickly talk about vaccine status, just because I've had a few questions about this over the past couple of months. And as part of health and safety planning, I know that some employers are looking to want to make inquiries into their employees' vaccine status. Now, you can't insist on knowing this data, so that's the first point to note. And so therefore, we would suggest that if you do have reasons why you want to know this information, we suggest you make it voluntary, i.e. you ask your employees to come forward and to let you know. And if you do make that information mandatory, then again, there are, mandatory for being able to attend the office. Then that is risky. There are privacy issues there, and there's potential discrimination issues there as well. Obviously, there was talk a while back in terms of vaccine passports, but as Louise has said earlier, the government's kind of parks that at the moment. So we think, well, if staff got more used to the idea of kind of sharing a vaccine passport on the NHS app more regularly, then perhaps they'd be more willing to tell the employees whether they've had the vaccine, because they see it more as a norm to divulge their vaccination status. But we don't know what's going to happen with that. And the other point to note is, if you do collect that data on vaccine status, that is special category data, and so you do need to be compliant with data protection. And of course, if you need any help in relation to data protection, then do let us know, and I'll pass it to our colleagues who will be able to help. So that was what I was going to say in terms of vaccination from an employment law perspective. Now moving on to the return to the workplace. So reluctant employees. So a brief reminder of Section 44 and Section 100 of the Employment Rights Act. We've covered this area a number of times in previous webinars. I'm not going to go chapter and verse into this area, but as a brief reminder, so these sections of the Employment Rights Act offers limited protection to employees who reasonably believe there to be a serious and imminent danger and exercise their rights to leave the workplace or take or propose appropriate steps to protect themselves or other persons from danger. So Section 44 is where an employee, and now a worker since May this year, where workers and employees are protected against suffering a detriment, and Section 100 is protection from dismissal and only applies to employees. It is an automatic unfair dismissal where you do not require 2 years service. I have mentioned on their risk assessments, just to link back to Lou and to say that when you're discussing the return to the workplace with employees and they're reluctant because of there being potentially a serious and imminent danger, this is where your risk assessments are key, to show that you've properly thought about the risks and you've mitigated the risks as far as possible to seek to encourage the employee to return to the workforce. And I'm going to talk about a couple of cases in a minute which help illustrate this. In light of a case, what the tribunals are doing at the moment is they will look at the danger and they'll consider the reasonableness of the decision of the employer, including the steps taken by the employer to remove the danger. And of course, that's where the risk assessments become important. And the tribunals will also consider the reasonableness of the stance of the employee in this situation as well. So the first case, these are all tribunal cases, not least because we haven't had the opportunities to get to an appeal tribunal at the moment because it's all so new. And so whilst tribunals aren't binding, obviously what this has done is this helped paint a picture in the direction of travel and is still very useful. So the first case, Fortuna Group, this was an employee who was reluctant to return to the office. He was concerned during lockdown last year with the risks of commuting to work and being in the office. He asked to either work from home or be placed on furlough. The employer instructed him that this was not possible because he couldn't perform his job from home and the business was far too busy to put him on furlough. And also, I don't think he was eligible for furlough either. The company, actually, Fortuna Group, they supplied and distributed PPE. So you can perhaps now understand how busy they were during lockdown last year. The employee was offered the ability to take holiday or unpaid leave. The employee declined and continued to ask to be furloughed. The employer then decided to dismiss the employee. He had less than 2 years service, so he brought a claim for automatic unfair dismissal under Section 100 for having taken steps to protect himself from the danger. The tribunal dismissed the claim. The tribunal observed that the government had announced in February that COVID could pose a serious and imminent threat to public health. And of course, the employee had emailed to express concern about commuting and attending the office. So they felt that he'd showed that he reasonably believed that there were circumstances of serious and imminent danger. But where his claim failed was that the employer had good reasons for not allowing furlough or working from home, but had offered, for example, unpaid leave. And therefore the employee's demands for furlough and working from home weren't appropriate steps to protect himself from the danger, and that's why his claim failed. Other recent cases, really quickly, we've got Rogers and Leeds laser cutting, and we actually sent out an e-briefing on this case, hence why I'm just going to talk about it quickly, because that will be on our website somewhere if you're interested. But this was a dismissal of an employee who refused to return to work until after lockdown had ended due to concerns about his children's health, who were both extremely vulnerable. But here, the employee hadn't raised any specific concerns about the working conditions, but rather just general concerns about the pandemic. And the tribunal looked at the measures that the employer had taken here, and that they felt that they'd taken adequate measures to limit the risk of exposure. And therefore, again, the claim failed. But here, again, it demonstrates the importance of implementing appropriate COVID secure measures. And I suppose where we are now, with the 19th of July approaching, it probably brings home the point that, this guidance is changing and evolving frequently. I suspect it still will in the future, hence we've got so many webinars on it. So it is to keep up to date with that. The final case, Gibson, this was a dismissal of an employee for raising concerns about the lack of PPE. This was in the hospitality sector. So the employee worked in a restaurant, and essentially the employer, in contrast to the other cases, just did not really have any adequate COVID measures, refused to supply PPE. The employee raised health and safety concerns as his father was clinically vulnerable, and the employee raised many issues in relation to PPE. His employment was terminated by text message, which is nice. He brought a claim for automatic unfair dismissal, and he was successful in that claim. The tribunal found that he reasonably believed there was a serious and imminent danger, and this led to him raising concerns in relation to PPE. And he had been dismissed because he was taking steps to protect his father. So there you go, there's a case where it actually fell on the side of the employee. So as I say, they're not binding, but they are helpful. And just a quick thought on the impact of vaccinations. Arguably, as more of the workplace population becomes vaccinated, one would hope that employees' concerns with regards to returning to the workplace are increasingly alleviated. However, we have a different COVID challenge that's seemed to emerge, which is that in a Chartered Management Institute survey fairly recently, 1 in 4 managers said that they will only be willing to return to the office because with fully vaccinated employees, fully vaccinated colleagues. So we can see that perhaps as more workers are becoming required to return to the office, there will be concerns perhaps about who's been vaccinated, who hasn't. And this would really trigger really complex issues. It really will, because of course you've got the right of privacy for those that haven't been vaccinated. We've already discussed about trying to collect data on this. And then you have to consider the reasonableness of the stance taken by the employee who's refusing to return if the employer can't, give assurances that all the colleagues have been fully vaccinated. So I'm not going to delve into that any further, because quite frankly, it's very complex, and probably the note would warrant an additional 15 minutes onto the webinar. I'm already conscious of time with the number of questions we've had, but just something to consider moving forwards. Hybrid working. We got the results of the poll in. Thank you very much. So 58% of you said yes, you are considering hybrid working. 28% of you said no, and 14% said no. So we are near enough at, well, 58%. We're approaching two-thirds of you saying that you're looking to move towards hybrid working. So that's really interesting. And for any of you that are not familiar with the term hybrid working, this is basically known as agile working, remote working, split working, blended working, and it's where essentially the employees work from home, say a couple of days a week, and work in the office the remainder of the time. So they split the time between office and home. So benefits, well, employers are potentially looking at their office space, being able to reduce overhead costs, potentially increase productivity. If an employee doesn't need to commute or have a lengthy commute to work backwards and forwards each day, then perhaps that time is, that travel time is put towards working. It's less stressful for the employee. So there's evidence that the time is gained, which leads to increased work productivity. Skills retention, potentially, if you allow employees to work from home, better motivation. Team flexibility, perhaps, geography and travel time between perhaps different offices, not so much an issue if employees are working from home and they've got the technology to meet. Drawbacks, culture, I think is a major one. Loss of perhaps potential the damage to the culture if everybody's kind of spread out and not with each other as often. Obviously, reduce face-to-face collaboration between colleagues and teams. A different management style may well be needed to oversee home workers, and managers may not be able to support or supervise junior employees as much as previously. So there's also the fact that you'll be reliant to a large degree on trust, and there could be a fear that some workers, when they're at home, won't pull their weight. And also we've got potential issues which I'll come on to in terms of what are you going to do about confidential information, data security and data protection, which has already come through on our questions. So there's some pros and cons for you to consider. So the practicalities of implementing hybrid working and the potential issues. Well, I looked at this yesterday and then I thought, crikey, we should have just done a webinar on this because there's quite a bit to cover. So whistle-stop tour, contractual position, always your first step. What does your contract say? Because your contract will obviously include, and it should include, the place of work. So does it just say place of work is the office, or does it say place of work is the office and the employee may be required to work from other locations? Obviously, the latter gives you more flexibility and will enable you to enforce the hybrid working. Obviously, you may have had temporary changes in place since lockdown, but of course, they're likely to be temporary unless you have already communicated something different. And if you do have the unilateral right in your contract to vary the place of work, then that's good. That is good. But it has to be unambiguous, and you also do still have to exercise it reasonably. Okay. If you haven't got the explicit contractual rights, then you need to basically get agreement from your staff to kind of have the hybrid working in the office and at home. Think about whether you want a one-size-fits-all approach. So a one-size-fits-all may initially be attractive to many employers because it's easier to administer. But agreements to hybrid working arrangements are more likely to be achieved if they can be tailored in some respects to the individual circumstances. Now, I appreciate that the larger your organisation and more employees, the much harder it is going to be to start considering employees on a case-on-case basis. Smaller employers, more likely. Can you trial the hybrid working? Because if you can trial it, you're more likely to get agreements. But of course, there might be some resource implications there. Some workers will relish a full return to the office and can't wait to get back into the office. Others will prefer working from home more than coming into the office. Can you be flexible amongst your workforce and not have a fix, everybody's in 2 days and everybody's out 3 days? Can you have, some are in 5 days, some are in 1 day amongst your workforce? The flexibility does increase the administrative and logistical burden, but it may encourage more agreement. And there's also some feedback that actually combining a move towards hybrid working and hot desking can meet with more resistance than simply proposals for home working. Therefore, if you're looking to do that and hot desking, it might be good to kind of implement it sooner rather than later, before everybody gets back to the office and gets reattached to their desk and their photo frames and the pot plants in their office and their location to the printer, for example. So that's something else to consider. If an employee refuses to the change, so if you've got no contractual right to change, and you've been unable to obtain the agreement of the employee, well, one option then is to unilaterally enforce the change, but that obviously runs the risk of breach of contract and then potential constructive unfair dismissal claims. You could then consider potentially terminating the contracts and re-engaging the employees on the new terms, but that does require you issuing notice, and for employees of long length of service, that would take some time. And also it runs the risk of potential unfair dismissal claims. And it's also the case that if you're going to do that, there's the potential for it to fall within the category of redundancy and redundancy pay to be due. And there's also collective consultation requirements to consider as well if you are looking to impose this on 20 or more employees. So really, dismissal and re-engagement will be the last result, last resort even, and consultation and dialogue with the employer will be really important. After making the change, you've got to look at your policies. Are they fit for purpose? Do they cover home working? Look at your expense policies. Do they need to be updated? Will you insist on supplying and approving all the IT equipment? Are you going to require employees still to come into the office, even if they're mainly working from home, to attend training, for example? Have you got a home working policy? Good idea to have a home working policy. And we've also got to have a quick think about data protection as well. So as an employer, you need to take appropriate measures to protect confidential information and personal data. So whilst up until now, the ICO has taken a very pragmatic approach to any non-compliance, given the circumstances and the very rushed working from home requirements. Obviously, moving forwards, there will be less leniency, so you do need to think about data protection. You also need to review the health and safety implications as well, and we've covered that. And this has also been, I've been asked this question, this is why I've mentioned it, and that's the right to privacy. So do you include in the contract the right at reasonable times and on reasonable notice to enter workers' homes in order to conduct risk assessments, install or repair IT, for example, and potentially remove any property on termination, company property, obviously, on termination. If you're proposing such clauses, then you need to ensure that only minimal and absolutely necessary interference with the privacy of home and family, and that could be a battleground for the future. Prior to the webinar, we had a couple of questions in, and one of them was that the question was that they're considering introducing a hybrid working model where employees are expected to spend 8 to 10 days in the office each month, the remainder of time at home. We expect this to be agreed on a flexible basis between the line manager and employee and may change from week to week. Do we need to issue anything in writing, an amendment to contract, or is policy and informal agreement with the individual sufficient? So for the person who's asked that question, I really hope that that's been really helpful and has helped answer it. Starting point, as I said, look at your contract. If it doesn't provide for working at an alternative location, for example, home, then you're going to need to get the employee's agreement, and you will also need to confirm that change to the contract in writing as well, because that's a Section 1 requirement. And in any event, having a policy covering expectations and logistics and such forth will be is a really good idea. So 3 minutes to go. I know there's a question, but what I want to do is just kind of get to the end of the the slides. At least I've covered everything, and then hopefully people will be able to stay on for an additional 5 minutes while we rest through the rest of the questions. Oh, what's a webinar without furlough mention? And I blame Lou for this because she insisted that I mention furlough. So it's winding down. So from earlier this month, we know that employers need to now contribute to 10% of the furlough pay. And from August to the end of the scheme, and it ends at the end of September, you need to contribute 20% to the furlough pay. And there is no rumours or anticipation that furlough will be extended beyond September. There you go, that's the furlough plug. There's a government consultation on flexible working. This has been on the cards for a while, even pre-pandemic, to be honest. But now the government has very recently confirmed its plans to commence a consultation which would consider whether flexible working would become the default option unless there are good reasons not to do so. A government spokesperson has apparently stated that this would not go so far as giving staff the legal right to work from home. And a government advisory group has also recently recommended that flexible working should be the default position. So watch this space on flexible working. Fire and rehire. There's been a lot of talk about this, and there was a recent ACAS report that noted that COVID has increased the use of fire and rehire, and that is what I've already mentioned before, where you dismiss and re-engage, normally to push through contractual changes to the contract. So the report identified that there were certain areas where fire and rehire were most likely to be used, and an employer wanting to change terms and conditions was high up on that list. ACAS has pointed to some concerns about this, obviously with the view that, perhaps the employees are at a very disadvantaged position, because of course if you're pushing through contractual changes, if you're needing to push it through because you haven't got agreement, more likely than not that means obviously that the changes are to the employee's detriment. And so ACAS has said perhaps this can be looked at. Perhaps we need tribunals to scrutinise the business rationale for the changes being imposed, and legislation to ensure employees don't lose continuity of employment when they're re-engaged. An area to watch out for. And long COVID, this is also an area to watch out for. The Office for National Statistics estimates that 1 million individuals in the UK have suffered or are suffering from long COVID. And essentially what I wanted to talk about here was the fact that there is so little information about long COVID in terms of the symptoms can vary from breathing difficulties to organ damage to mental health implications. And whilst the unions are pushing for long COVID to be classified automatically as a disability, I'm not sure that would happen, but we do have to have in mind a potential for an employee with long COVID to have a disability. But with the lack of medical knowledge of long COVID and indeed how long it may be, will it hit the 12 months to classify as long term to meet the definition of disability under the Equality Act? We don't know. But if you've got staff with long COVID, the ACAS guidance is you treat them as you would any other poorly employee, discuss with them, find out about their symptoms, refer them to occupational health to try and find out some more, and to try to get a prognosis as best as you can. Consider whether there are adjustments that you can make to enable the employee to work from home. To perform their duties, not work from home, but any adjustments that you can be making. For example, work from home or reduced hours. So I've just put it on there because I think that's something that we will be looking at in time to come. Employees who are unfortunately very poorly due to long COVID and who struggle to perform their duties. So there was a lot to cover. Lou, could you help me out as to where we are on the questions? We've got one question that was raised prior to the webinar, but I'd prefer to deal with the ones first that have come through just now.
So I think you've already covered off with regards to the one, if an employer refuses to return to the office and we cannot accommodate working from home, are they in a position that they should resign? I think you've covered that off in that if they cannot do their job at working from home productively, then I think you need to have a discussion with them about, and they're refusing to come to the office, then I think you have got to have that discussion, then take those next steps. And perhaps it will be a mutual going, separate ways, and I think you've covered that off already.
Mm-hmm.
The next question you have is, can we justify forcing return to work and refusing continued home working if the employee has worked from home successfully for the past 15 months?
It's kind of the similar point, isn't it, really?
It is. And I think you've already covered it in terms of what does their contract say, looking at the terms of their contract, and have that dialogue with that employee. What are your concerns about them working from home? Is it the fact that actually you can't supervise them properly, or their productivity is failing? And you need to have that discussion. If they are able to successfully work from home and you are able to accommodate it, then perhaps they do have reasons to dispute what's going on. But again, I think you have to have those discussions, and it's going to be very much business and individual specific, I think, in those issues.
Yeah, and I think and also just ask the employee why they don't want to come back to the office, why they want to work from home, because of course if you've got potential disability issues or other reasons, then you just need to know what the risks are if you force that through.
You've got another question, but I'm going to deal with the one that's just come through first, because that ties into what we've just talked about. So our managers feel it isn't fair. Some people get to work from home when others can't. Is that enough to refuse to allow them to continue to work from home?
I don't really think so.
No.
I think you've got to probably take a bit of a pragmatic view about it. It's my opinion on that, really.
I mean, although the managers may feel that, I guess it's also down to the employees and what their thoughts are on it as well.
And I think at the end of the day, if the others can't, they've been employed to do a specific job, and if they can't do it from home, they can't do it from home. And if others can, then they can. That's a difficult one. Because of course you don't want to reduce morale from those that have to come into the office, but I think you've just got to be clear as to why some roles can be performed from home and why others can't.
And then going back to the one that came in, what about the right to keeping to working hours, such as not being expected to receive and respond to emails at any time of the day?
I like this question because it's obviously from an employer that cares about its employees, because I think what we have noticed is with the home working that suddenly the blur between your whilst you may not need to commute, the blur between your downtime and your private life and your working life is becoming increasingly blurred. And I think certainly that's why it's nice to have a home working policy where you can raise expectations as to actually, out of hours contact at 8 o'clock at night isn't acceptable if you're demanding an answer there and then. But I suppose perhaps the question is also, what about employees who are saying, well, actually I'm working from home and I'm only going to work 9 till 5. And you as an employer said, well, we need some flexibility. Well, then I would look at your contract, because no doubt 9 out of 10 contracts, if not more than that, actually will say you'll be expected to perform work between this hour and that hour, and additional time to fulfill your additional reasonable time to fulfill your job role without additional remuneration, normally it says. And so the principle would be the same. So I think how you approach employees and their hours and the requirements of their job would be the same as when they're in the office or at home.
That's all of them.
That's all of them. For those of you who've got to disappear, thank you ever so much for from listening and watching. If when you leave, you could kindly just fill out the quick survey just to kind of let us know what you thought of the webinar. Be really, really grateful, because we always appreciate your feedback. The one other question that I got prior to the webinar was in relation to a business who's receiving a number of requests from employees to work from other countries for prolonged periods of time. For example, they've got parents or a holiday home in India or Spain, and they've since apparently received a formal flexible working request for an individual to spend over half of each month in Spain. Whilst the individual's been able to demonstrate he can work effectively from Spain, there are so many other considerations around tax, employment legislation, etc. How do we ensure that we're complying with all of the considerations? Well, that's a huge topic, a huge question. And essentially what you need to do is you need to create yourself a checklist of everything that you need to consider, and then tick it off, work your way through it. There's a long list of things that you need to consider, some of which you've already flagged, but you've got to consider, for example, practicalities of how the reporting line will operate whilst the employee is working abroad. You've got to think of any tax consequences. How will communication work? Here comes the time point. If there's a time difference, how's that going to work when there needs to be meetings? Are you going to have to adjust the employee's working hours? What about equipment? How are you going to ensure that the employee's got all the equipment they need to be able to work remotely abroad? Cost contribution by the employer. Certain jurisdictions may indeed enforce a legal obligation on the employer to pay employees remote working expenses and provide certain equipment. I suggest that you do need to definitely record the arrangement in writing, confirming that they'll continue to work for the UK employer and who the employer is, and that the employment contract will remain subject to the laws of England and Wales, and that UK courts have jurisdiction. However, that does not prevent avoidance of the country's so-called mandatory rules. So, for example, anybody working in the UK has certain statutory rights, and parties can't contract out of mandatory rules. So therefore, you're going to need to know the labour laws of the country they're proposing to work from. So seek employment law advice in relation to that host country. And this may well also affect your ability to terminate the employment, depending on the rules in that particular jurisdiction. In your written agreement, you want to confirm the liability of the employee for any additional income tax or employee social security contributions resulting from their period of time working abroad. Got to consider the immigration issues, data protection. If the employee is processing data, processing personal data, consider which data protection regimes apply in that jurisdiction, and again, seek local advice. Review pension entitlements and other employment-related benefits, for example, permanent health insurance, private medical. Check the scheme rules. Will they apply when the employee is working from abroad? Local health and safety requirements. Think about that. Check the business's insurance policies and consider whether the existing cover is adequate. For example, if the employee has a work-related accident whilst abroad, is that covered? If you've got insurance in relation to your IT equipment, will it be covered if that IT equipment is taken abroad? So there's a huge amount to consider, and unfortunately you're going to have to do this. You'd have to do this on a case-by-case basis depending on the jurisdiction. Create a checklist, work your way through it, and obtain, obviously, UK employment law advice and local advice where needed. I hope that provides a summary to answer that question. Was there anything else, Lou? You're on mute. You're on mute.
Yeah, I am. That's the first time I've done that. Yeah, no, we've covered everything. So I think, yeah, we've answered all the questions. And if not, if people want to email in to contact either of us with any follow-up queries, then please do. Yeah, well, apologies that we overran, but there was a lot to cover, and we also wanted to make sure that we answered all your questions. Yeah, thank you. Look forward to hearing from you soon, and we will get our head scratching as to the topic of the next webinar. And if you could just complete the quick feedback survey at the end, we'd be very grateful. So thank you very much. Goodbye. Thank you.